another edition of ABI Podcast. This is Melissa Jacoby. I'm the ABI Scholar in Residence for the Spring 2016, and I'm also a law professor at the University of North Carolina at Chapel Hill. Today's topic is an unusual governance structure in an unusual kind of bankruptcy case. The structure is a committee of students in a Chapter 11, and the Chapter 11 case is Corinthian, which was among the largest for-profit post-secondary education companies in the United States and Canada. We're lucky to have two guests today who represented that committee of students: Scott Gautier, a partner at Kaplan in LA, and former member of ABI's board of directors, and Chris Ward, a shareholder at Polsinelli in Wilmington, Delaware, and also practice co-chair there, and currently on the ABI's board of directors. Welcome to both of you.
Thank you, Melissa.
Good afternoon.
So, Scott, let me start by asking you some about the context here. So federal education laws deter the filing of education bankruptcies. So it really wasn't a foregone conclusion that even a truly financially distressed education provider with no liquidity would enter bankruptcy. So how did Corinthian get into bankruptcy? Why did it file?
Corinthian had sold all the schools that it could. Ed was effectively blocking the sale of the remaining schools and campuses. And a company like Corinthian will often utilize Chapter 11 to benefit from the automatic stay. If you recall, there's a lot of director and officer litigation that was going on, and there was a lot more that was threatened. And it'll utilize a formal process to dissolve the company and bring things to a close and hopefully extricate some of the directors and officers from litigation, or at least put a process in place by which everything is funneled to conclusion. And so only where we see a private school that is out of business and done are we likely to see a formal bankruptcy process.
So we're using bankruptcy for the other tools that are offered, as we see in many Chapter 11s, rather than a traditional reorganization, which would never have been possible here.
Absolutely. It is completely within the Department of Education's discretion, and I don't think they would ever approve a school continuing to remain eligible for Title IV funding after it has filed for bankruptcy. The law is that once you file for bankruptcy, you're no longer eligible without Ed's consent to continue to have access to Title IV funding.
So Corinthian files. The U.S. trustee appoints an ordinary creditors committee in the case, but there was a request and apparently granted to have a special student committee. So, Chris, take us through the basis for appointing that special committee, and who had to be convinced to make that happen, and was anyone skeptical about it?
Well, I think the best way to start this was that the matter originally came in through Scott and Kaplan, as well as public counsel, who had the relationship with the students. And they worked with the students prior to the bankruptcy filing and leading up to the bankruptcy to organize them and get an ad hoc committee set up of the students. It was at that point that my firm in Delaware was approached to be local counsel, co-counsel to the committee. And our role was to serve as Delaware Bankruptcy Counsel and to advise the students and Kaplan and public counsel on procedure in Delaware and to really get them familiar with our court system and our trustee's office. Now, this case was in Delaware, but this could have been in any jurisdiction. I think one of the underestimated facts in any bankruptcy case is the ability of outside counsel to rely on local counsel in the jurisdiction to become familiar with bankruptcy practice and procedure in that jurisdiction. Polsinelli in particular in this case was needed to talk to the Office of the United States Trustee and make introductions between all the students and the lawyers involved. And in any case, it's always great to have a firm with a good relationship with Chambers, because getting in with Chambers and the court system is the most efficient way to get the committee process moving. What we did here was Kaplan had sent a letter to the Office of the United States Trustee requesting that the trustee form an official committee of students after the official committee of unsecured creditors was formed. That is typically the first step in the process to have an alternative committee formed, is to have it done by letter, specifically requesting that the Office of the United States Trustee solicit interest in an alternative committee. The trustee, by the bankruptcy code, automatically solicits interest of general unsecured creditors in every case, and assuming there's 3 interested unsecured creditors is going to form a committee. We've seen a lot of instances with this ad hoc committee approach requesting that the trustee form an alternative committee. I think that the largest group we've seen there's equity committees in several cases. We've also seen some landlord committees and retiree committees. In this instance, we approached the trustee about soliciting interest in a student committee. After the trustee receives that request, they typically go to the debtor and the lender and other major constituencies in the case and ask them to reply as to whether a committee is needed in this particular case. The trustee then makes a decision on whether to solicit a committee or not. And I think it's important to note that what the trustee does in these cases is the trustee gauges interest in whether it should solicit creditors in order to serve on an alternative official committee. It's not that the trustee actually forms a committee. What the trustee does is, if it determines in its sole discretion, basically, if a committee is needed, it solicit interest, and it still has to receive at least 3 interested creditors that are willing to serve on that alternative committee.
We were consulted specifically for our bankruptcy advice. We were asked specifically, again, prior to Corinthian's bankruptcy, whether we could help students utilize Chapter 11 on an involuntary basis against Corinthian to avoid the anti-class agreements and the binding arbitration provisions that are contained in their enrollment agreements. As most bankruptcy practitioners know, Chapter 11 does not really offer a way to avoid binding arbitration or class waivers. However, what we noted to the students is that if we could get Corinthian into a bankruptcy proceeding, which we thought was unlikely as long as they were going to continue to operate because of the Title IV issues that we just spoke about, it would offer the opportunity for collective proceedings, even aside from a class action, through a class of creditors that could participate in the case. So we knew that we wanted a student committee, that we'd like to see Corinthian in a bankruptcy case because there are these anti-class waivers and these mandatory arbitration provisions that made it difficult for the students to act as a class. Once they filed, we did the letter, but we reached out to Chris Ward in particular at Polsinelli. As Chris has said, we need local counsel in Delaware, but even if we didn't need, we're required to have local counsel in Delaware, you want local counsel like the Polsinelli group that has the relationships with the U.S. Trustee's Office, that knows the courts and knows the process, because 1102 is a discretionary statute. No one has to give you a committee just because you ask for it. And so it's the way that you ask for it and the way you make your arguments that was so important to us, and to be able to utilize Chris and his firm was really key to making sure that we got a committee appointed.
So, Scott, you raised some interesting points about the nature of the claims that the students have. Students are both debtors and creditors, and of course a lot of different ways, but even with respect to Corinthian, there seems to be a lot of different things the students might have wanted out of this process, whether it is money or relief from student loans, the ability to finish their education. How did you prioritize those issues?
The Corinthian students sit in a different position than many other students at many other schools in terms of their student loans. These are not students that were just, overcharged and they find that their educations, they're unable to pay for their overpriced educations. These are people that were lied to and deceived and didn't receive what it was they were promised that they would receive. And so the difference being in that the Corinthian students really, we believe, should not be responsible for these obligations that were garnered by fraud and deceit. And so we tried to utilize the Corinthians bankruptcy case to give the students some leverage with the Department of Education in terms of negotiating for greater relief and cancellation of debt.
And can you shed any light on how you did that? I know some of it must be confidential, but how did you work with the Department of Education? How did you exercise that leverage?
What we tried to do, we tried to utilize the automatic stay and extend that to the repayment of student loans. We tried to infringe upon the Department of Education and get the bankruptcy court to infringe upon the Department of Education's discretion in the process. And I think the bankruptcy court helped us in that regard and gave us some leverage in terms of its rulings from the bench. And I think as the Department of Education saw that the bankruptcy court may infringe on its discretion in certain ways, it was more willing to talk with us. I would say that would have to recognize that the California Attorney General's office that had been working on this problem since 2007 and had dedicated probably tens of millions of dollars to investigating and auditing Corinthian records historically, was able to do much more than what we were able to do in the span of 6 to 8 months during the case. We were happy to be able to lend our voice and allow some of the students to lend their voice to the issues. But to date, I would say that the real gains with the Department of Education in terms of what they've done for Corinthian students has been mostly based, almost entirely based on what the California Attorney General was able to do.
So you're involved in an ongoing basis in this case. Can you tell us where things stand now and how they appear relative to how they looked at the time that there was a plan being confirmed?
Sure. One of the things that the student committee was able to do was to modify the plan. The plan that was initially proposed in the case would have been a single pot plan. It would have provided absolutely $0 to any creditors, and it would not have provided for any sort of a group that could continue to work and get paid, to work for student problems. And what we wanted was a little bit of cash that was available in the estate to pay for a trust